Okay, so here is now the continuation of our discussion on negotiable instruments. We are now in liabilities of parties. I want you to take note that when it comes to liabilities of parties, the parties here are being classified based on the nature of their liability. So there are parties who are primarily liable, there are parties who are secondarily liable, and there is even a party who has no liability in the instrument. So if you are a party primarily liable, when we say primarily liable, we're actually referring to the maker in a promissory note, to the acceptor in a bill of exchange. When we refer to secondarily liable, we're actually referring that to a drawer as well as to an endorser. And you have to take note that there are subclassifications of these endorsers. You have your irregular endorser, you have your general endorser, and then you have your qualified endorser. Now, how about that party that I'm referring to who has no liability? I am actually referring to a drawee, person named in a bill of exchange, to whom you will present that bill of exchange for acceptance, but who has not yet accepted it. And we all know that if the drawee did not yet accept that bill of exchange, that command to pay, the drawee has no liability in your instrument. You might wonder what is so important about being primarily liable and being secondarily liable. Well, it means that if you are a person primarily liable, your liability is already automatic. Take, for example, the case of a maker. The moment you have issued your promissory note, your liability in that instrument has been created. If you are an acceptor, the moment you have accepted or you have conceded or you have uh, accepted that order of the drawer to pay, the liability has already commenced. No additional act is necessary or is required to be undertaken in order to hold you liable in your instrument. But if you are a person secondarily liable, before the liability will attach, there are things that must first be complied with so that your liability is created. There are two things that must be present so that the liability is created. First, the instrument should have been dishonored, either by non-acceptance or by non-payment. And the second is that you should have been duly notified of the fact of dishonor. If the instrument has not yet been dishonored, if you did not yet receive the notice of dishonor unless unless you have not waived the same, your liability is not created. So, if you are a person secondarily liable, there are two requirements that must concur. There are two requirements that must be present so that the liability is created. First, it should have been dishonored either by non-acceptance or by non-payment. And the second one is that you should have been duly notified of the fact of dishonor. In other words, you should have been served with a notice of dishonor. If there is an absence of either or both, the liability of a person secondarily liable is not yet created. I want you to take note also that in connection with this discussion on liabilities of parties, you notice that there are admissions, there are warranties that are being made by these parties. And the rule here is that once you have made a particular admission, once you have warranted something, you can no longer undertake a defense that will contradict your very own admission or your very own warranty. So you have waived a defense that will contradict your own admission, your own warranty. Okay? So let's take a look at the person primarily liable, the liability of a maker. The maker, in making that instrument, engages that he will pay it according to its tenor. He likewise admitted the existence of the payee and likewise admitted the capacity of the payee to endorse the instrument. So if you notice, the liability of our maker here is according to the tenor of the instrument. So what is this tenor of the instrument? The tenor of the instrument actually refers to the amount that is appearing on the face of your promissory note. So take, for example, the following. I promise to pay Peter or order 1 million pesos signed Mike. So Mike here is the maker. Mike, in making a promissory note and subsequently issuing it to Peter, Mike binds himself to pay Peter or the order of Peter the amount of 1 million pesos. 1 million being the tenor of your instrument. Okay? So 1 million being the tenor of the instrument. And Mike, as the acceptor, he binds himself to pay according to the tenor of the instrument. Not only that, in issuing the instrument, Mike likewise admitted the existence of the pay. So just like what I've mentioned to you a while ago, once you admitted something, you can no longer contradict your own admission. You can no longer raise a defense that will contradict your very own admission. Considering that Mike, the maker, admitted the existence of the pay, what do you think is a defense that Mike has practically waived when he admitted the existence of the pay? He can no longer raise the defense that Peter, the payee, is a fictitious or a non-existing person. So he cannot free himself from liability by claiming that there is no pay, that the pay is just a product of his imagination. He can no longer raise that particular defense because he admitted that pay Peter is a real person, a real and an existing person. Besides admitting the existence of the payee, he likewise admitted the capacity of the payee to endorse. So having admitted the capacity of the payee to endorse, what is now the defense that he cannot raise? In that particular sense, the defense that cannot be raised by our maker is the fact that payee is an incapacitated person. That payee cannot give valid consent. That payee, for example, is a minor. That payee, for example, is insane. That payee, for example, is a deaf mute who does not know how to read or write. Those are matters that can no longer be raised by our maker because he already admitted that the payee is capacitated to endorse or to negotiate the instrument. Okay? So, let's now consider Section 62, liability of an acceptor. Again, that's also a person primarily liable. What are the admissions? What's the extent of the liability of an acceptor? The acceptor, by accepting the instrument, binds himself to pay according to the tenor of his acceptance. If you're going to compare that with the liability of a maker is liable according to the tenor of the instrument as to the amount appearing on the face of the instrument. Whereas, insofar as the acceptor is concerned, his liability would be according to the tenor of his acceptance, not on the tenor of the instrument, but the tenor of the acceptance, the amount that he is actually willing to pay and to deliver to the pay or to the order of the pay. What did he accept or what did he admit? Okay. The acceptor, in accepting the instrument, likewise admitted the existence of the drawer, the genuineness of the drawer's signature, the capacity of the drawer to draw the instrument, the authority of the drawer to draw the instrument, and then existence of the pay, as well as the capacity of the payee to endorse. So if you notice, just like the maker, he admitted the existence of the payee and then the capacity of the payee to endorse. So with this, let's consider this one. The acceptor admitted the existence of the drawer. What is the defense now that cannot be raised by the acceptor, considering that he admitted the existence of the drawer? Just like in our previous discussion. Okay? If you admitted the existence of the pay, then the defense that you cannot raise here is the pay is not is fictitious or non-existing. In like manner, if you have admitted the existence of the drawer, you likewise waive the defense that the drawer is a fictitious or a non-existing person. How about this one? The genuineness of the drawer's signature. When we were still in section 23, I have told you that the acceptor cannot raise the defense of forgery, but only insofar as the drawer's signature is concerned. Why? Because under section 62, he already admitted the genuineness of the drawer's signature. But take note, the admission made by the acceptor here is simply limited to the drawer's signature. No admission whatsoever has been made insofar as the signature of the pay is concerned. No admission has been made as to the genuineness of the endorser's signature. No, sir. What has been admitted by our acceptor here is only the genuineness of the drawer's signature. So it is only if the drawer's signature is in question that he cannot raise the defense of forgery because he admitted that the drawer's signature is genuine. And then another admission made by our acceptor is that the capacity of the drawer to draw the instrument. Capacity of the drawer to draw the instrument. What's the meaning of that? It means that the acceptor has admitted that the drawer has the legal capacity to actually give consent to the instrument. That he is not a minor, that he is not insane, that he is not deaf mute, does not know how to read or write. And not only that, the authority of the drawer to draw the instrument. Pareho lang ba yan? Capacity and authority? The answer is no. Capacity, personal yon doon sa part ni drawer na hindi siya minor, na hindi siya insane. But when we talk about authority, it presupposes here a situation whereby the drawer is an agent. And it follows that the drawer here is acting within the scope of that authority. So the acceptor, in accepting that instrument, he admitted that if the drawer is an agent, the drawer agent is acting within or pursuant to the authority conferred in his favor by his own principal. So yun yung mga admissions, and with those admissions, there are things that our acceptor cannot admit. Again, a reiteration, yung sinabi ko kanina, and any defense that will contradict the aforesaid admissions cannot be validly raised as a defense. So take, for example, forgery of the drawer's signature. But if what has been forged is a signature other than the signature of the drawer, he can still perfectly raise the defense of forgery. Okay, kagaya dito, forgery of the payee or endorser's signature. That is a valid defense because the acceptor did not admit the genuineness of the signature of our drawer. Okay? Continuation. The drawer, by drawing the instrument, admits the existence of the payee. So we are now in party secondarily liable. So he admitted the existence of the payee as well as the capacity of the payee to endorse, and engages that on due presentment, the instrument will be accepted or paid or both according to its tenor, and that if it will be dishonored and the necessary proceedings of dishonor will be taken, then he will pay the amount thereof to the holder and to any subsequent endorser who might be compelled to pay the instrument. There's no need to repeat this one. Existence of the payee, capacity of the payee, same with what we have discussed a while ago when we were still in maker. Okay, liability of maker. Now I want to focus the discussion here. Engages that on due presentment, the instrument will be accepted or paid or both according to its tenor. So the drawer, by drawing and subsequently issuing that instrument, he actually made a warranty that the instrument would later on be accepted by our drawer. So if, by our drawee. If the drawee did not accept that, then there has been violation of that warranty made by our drawer. If the drawee did not accept it, then technically there is now what we call as dishonor by non-acceptance. The drawee here did not only warrant that the instrument will be accepted by our drawee. He likewise warranted that our drawee will not only accept it, but he will also pay the same. Or if it's not accepted, then it will be paid. So those are the warranties. So if on the due date, although it was accepted, but later on the due date, when the holder of the instrument will go to our acceptor to demand payment, the acceptor now refused to pay, then again, there is breach of that warranty made by our drawer that the instrument will be paid. Or in a situation whereby the drawee neither accepted nor paid the instrument. In those instances, there will now be what we call as dishonor of our instrument. Either dishonor by non-acceptance or dishonor by non-payment. So, if there has been dishonor already, if there has been a violation of the drawer's warranty, that the instrument is accepted or it will be paid or both accepted and paid, does it mean then that our drawee is now liable? This is what I've been telling you a while ago. That if you're a person secondarily liable, the liability is not actually automatic. It does not mean that when the instrument has been dishonored by non-acceptance or by non-payment, the liability of the drawer will now attach. No, that is not the case. another step must first be undertaken in order to create the liability of the drawer being a person secondarily liable. Ano yung susunod niyang gawin? Besides the fact that there should have been dishonor of the instrument by non-acceptance or by non-payment, ang susunod dapat na gawin ng holder, if he wants to demand payment from our drawee, is that he should now notify the drawer of the fact of dishonor. Saan mo makikita yon? Itong naka-highlight na to. That if it is dishonored and the necessary proceedings of dishonor will be taken, then, sabi ni drawer, I will pay the instrument to the holder or to any subsequent endorser who might be compelled to pay the same. So, if it has been dishonored by non-acceptance or by non-payment or both non-acceptance and non-payment, as long as you will serve to him the notice of dishonor, then that's the time that he is liable. And to whom is our drawer liable? Sabi niya, I will pay the holder or any subsequent endorser who might be compelled to pay the instrument. Now, tingnan natin ito. So take for example the following. Drawer with P as the payee. Okay. Payee yan. And A as the drawee. So what happened? Drawer issued that to P, and then P to X, X to Y. Y is the present holder of our instrument. Y, upon receipt of that instrument, what did it do? Y went to A, presented it for acceptance. What happened? It was dishonored. Dishonored by non-acceptance. Considering that the instrument has been dishonored by non-acceptance, then technically there has been violation of the warranty made by the drawer that the instrument at the time it will be presented for acceptance, that it will be accepted. So there has been dishonored by non-acceptance. If the instrument has been dishonored by non-acceptance, can Y now hold the drawer liable? The answer is not yet. Why? Sabi kasi ni drawer doon sa section 62 that if the instrument is dishonored, you served him first the notice of dishonor before he will pay the holder or any person who might be compelled to pay it. So paano nangyari yon? So ang dapat niyang gawin, Y, when he presented that instrument to A, the drawee dishonored it for non-acceptance. The next step now that should be undertaken by Y is to serve notice of dishonor to the drawer, to P, and then to X. After Y served the notice of dishonor to the drawer, that's the time now that the drawer can be held liable. So drawer, dalawa na yung requirements na nag-concur. First, there has been dishonor, and then the second one is that there has been notice of the dishonor. Considering that the drawer has been notified of the fact of dishonor, the drawer is now liable to Y, the holder. Pero ang sinabi doon sa section 62, sabi doon, he will pay the holder or any person who might be compelled to pay it. Who is that any person who might be compelled to pay it? So, halimbawa, di ba sabi ko kanina, if the instrument has been dishonored, Y should now serve notice of dishonor to the drawer, to P, and then to X. Di ba? Because P and X, they are endorsers and they are also parties secondarily liable. And since the instrument has been dishonored and since you have also notified them of the fact of dishonor, then it follows that P and X are also now liable to Y. So ano ngayon ang ginawa ni Y? Y, instead of demanding payment from the drawer, ang ginawa niya, he demanded payment from X. So it was X who paid Y. Now, ano ang sinabi ni drawer? If the instrument is dishonored, just give to me the notice of dishonor, then I will pay the holder. Si Y yun. Or any person who might be compelled to pay it. Sino si any person who might be compelled to pay it? That would now be X. Or it could be P. Depende kung kanino ngayon maniningil si Y. Kung si Y naningil kay X, then X, and then the drawer is liable to X. If Y demanded payment from P, then the drawer is liable to P. Okay, so ganon yung rule natin dyan. Let's go back. Okay, and then I want you to take note also, the last part of your section 61, that the drawer may insert in the instrument an express stipulation negativing or limiting his own liability to the holder. Paano yun? Just like your qualified endorser by adding the word without recourse. Okay, in which case, the liability of the drawer will attach only if there is violation of these warranties and it is shown that he is aware of these of the violations of these particular warranties or admissions. Okay? Liability of an irregular endorser. Who is this irregular endorser? Irregular endorser is any person who affixes signature in the instrument in blank before the delivery. Na-explain ko ito sa inyo noon that you are considered as an irregular endorser kasi mas nauna yung endorsement mo bago yung actual delivery or issuance ng instrument. And to whom are you liable? Okay? Depende. Okay? If the instrument is payable to the order of third person, then parties after the third person. Okay? You are liable to the payee, okay, and subsequent endorsees. If the instrument is payable to the order of the maker, then parties after the maker or of the drawer. And if it is been made for your accommodation, then parties subsequent to the payee. Ganun lang. And then warranties, 65 and your section 66. Section 65 refers to the warranties made by a qualified endorser as well as by a person who negotiates an instrument by delivery. Section 66, on the other hand, refers to warranties made by a general endorser. Siguro taka kayo. Sir, wala naman tayong napag-aralan na general endorser. Saan mo na naman pinagkukuha yung sinasabi mong general endorser? Well, very easy. General endorser refers to any kind of endorsement other than qualified. So, kung gumawa ako na po ng endorsement na blank, gumawa ako ng special, gumawa ako ng conditional, gumawa ako ng restrictive, gumawa ako ng facultative na endorsement, I am classified as a general endorser. Okay? So, any other endorser other than qualified shall be classified as a general endorser. So, if you're a qualified endorser, what are your warranties? First, you warrant that the instrument is genuine in all respect what it purports to be, that you have good title to it, that all prior parties had capacity to contract, and that he has no knowledge of any fact which would impair the validity of the instrument or render it valueless. So these are the four warranties of your qualified endorser. Maalala nyo ba yung sinabi ko noon when we were still in qualified endorsement? That qualified endorsement limits the liability, the extent of the liability of the endorser. Diba sabi natin, the liability of the endorser qualified endorser will attach only if there will be violation of the warranties. Ito yung mga warranties na sinasabi natin. That the instrument is genuine and in all respect what it purports to be. That is good title to it. That all prior parts, etc. Qualified endorser is liable only if there is violation of these warranties. And only if he has personal knowledge of the fact which would impair the validity of the instrument or render it valueless. In other words, even if the instrument is not genuine because there are material alterations or there is forgery, or even if a prior party has a defective title or a prior party has is incapacitated to a contract, as long as he has no personal knowledge of those defects, his liability will not yet attach. Okay? The liability will not yet attach. Take, for example, the following. Okay? So, maker, he issued that to P, P to A to B, B thereafter negotiated that to C through qualified endorsement. So by adding the word without recourse, B to C, C to D, D to E. Ayan, oh, hanggang C na lang pala. Ayan. How about if unknown to be qualified endorser, P is a minor. So prior party is incapacitated. And then unknown to be A forged the signature of P. And then A made material alteration. So if you notice, of the warranties made by the qualified endorser, na-violate na niya halos lahat. Because a prior party is not capacitated. There has been material alteration, there has been forgery, so the instrument is no longer genuine and in all respect what it purports to be. So does it mean then that B, our qualified endorser, is already liable because there has been violation of the warranties? Well, it depends. If B has knowledge about these defects in the instrument, then he is liable. But if he's shown that he has no personal or actual knowledge of these defects in the instrument, he is not yet liable. In other words, if you are a qualified endorser, even if the instrument is defective, if it's shown that you have no personal or actual knowledge of those defects, you cannot yet be held liable. That is the way by which you can limit your liability in the instrument. Your qualified endorser has also the same warranties as a person who negotiates an instrument by delivery. However, the warranty of a person who negotiates an instrument by delivery extends only to his immediate transferee. Yung pinag-abutan lang, yung pinagbigyan lang niya, yung pinag-deliveran lang. Kung ibang tao, hindi na. So, similar to our discussion before when we were still in negotiation. Section 66, warranties of a general endorser. Kung makikita ninyo, the first three warranties are actually the same. That the instrument is genuine or respect what it purports to be, that he has good title to it, that all prior parties have the capacity to contract. So pareho lang. Instrument is genuine and respect what it purports to be, that he has good title to it, that all prior parties have capacity to contract, and then ito ang pamatay. That the instrument is at the time of the endorsement is valid and subsisting. Anong ibig sabihin nun? Ibig sabihin that if the instrument has a defect, it does not matter whether our general endorser has knowledge of that defect. If the instrument has a defect, then the liability will now attach. No qualification shall be made. Alam ba niya o hindi niya alam, it does not matter. He being a general endorser, the liability is now created. And not only that, if you are a general endorser, hindi lang 4 ang warranties mo, magiging 5 kasi kapareho mo na yung drawer. That the instrument at the time of the endorsement is valid and subsisting. That engages that on due presentment, it shall be accepted, paid, or both. And as the case may be, according to its tenor, that if it is dishonored, etc., etc., etc. Okay? So, going back to our illustration a while ago, kagaya dito. So, M made a promissory note. And then, he issued that to P, P to A to B. And then, instead ngayon na qualified endorsement, sabihin natin, blank endorsement. Okay, special endorsement. So, B made a special endorsement. Considering that the endorsement is special, then endorser B is just a general endorser. Unknown to B. P is a minor. Unknown to B, A forged the signature of B. Unknown to B, A made material alteration. Is he already liable? Is he already liable? Was there violation of the warranties? The answer is yes, there was violation of the warranties. But is he already liable? If C now, at the time he will present the instrument to the maker for payment, M refused to pay C, then C, by just giving notice of dishonor to B, B is now liable. Pwede bang sabihin ni B na, hindi ako dapat maging liable, hindi naman ako aware na si P ay minor. Hindi naman ako aware na si A nag-forge ng signature. Hindi naman ako aware na si A ay nagpalit lamang ng amount doon sa instrument. Inosente po ako. Is that a valid defense on the part of B? The answer is no. He being a general endorser, if the instrument has a defect, he is already liable because the warranty states that the instrument is valid and subsisting at the time of the endorsement. It does not matter, therefore, whether he has knowledge or actual or personal knowledge of those defects. The liability will already commence. Okay? So, that's the discussion on warranties of a general as well as a special qualified endorser. And then order in which these endorsers are liable, they are liable according to the order in which they endorse. So if you are an accountancy student, di alam mo na yung sinasabi natin na LIFO tsaka FIFO, yeah? The order in which the endorsers are liable is actually FIFO. First in, first out. Ikaw na unang endorser, ikaw yung unang magiging liable unless they agreed otherwise. So as a respect to one another, endorsers are liable primarily, okay, prima facie, in the order in which they endorse, but evidence is admissible to show that as between or among themselves, they have agreed otherwise. In other words, a general rule is FIFO, except when there has been agreement, then that would now be LIFO, last in, first out. What is the liability of an agent or a broker? If you're going to read section 69, ang sabi niya doon, the warranties of an agent or a broker would be that of section 65, di ba? Pero a closer look at section 69 states that the broker or agent who negotiated the instrument negotiated it without endorsement. In other words, the agent delivered the instrument. So considering that the agent or broker delivered the instrument, the warranties will be under section 65 and the warranty extends only to the immediate transferee. But if the agent or broker made a special endorsement, he made a restrictive or he made a blank endorsement or a facultative or a conditional endorsement, what will be the warranty of that agent or broker? Then the warranty will be 66 kasi general na siya, hindi na siya nag-negotiate lang by way of delivery. So to reiterate, yung section 69, sinabi dito na yung warranty ni agent or broker is 65 because the agent or broker in section 69 negotiated the instrument through delivery only. He did not negotiate it through special or through blank, etc., etc. Okay? Kung yung agent mo nag-negotiate through qualified, then it's 65. If yung agent mo nag-negotiate through blank, then that would be 66. So let's take a look at the illustrative cases. Broker negotiates an instrument by delivery, then that would be 65. If the agent negotiates an instrument through qualified endorsement, that would still be 65. But if the broker now negotiates an instrument through special endorsement, then that will now be section 66. Because in this case, he will now be considered a general endorser. So let's consider also Unit 2, Module 4, Presentment for Acceptance. You have to remember that not all bills are required to be presented for acceptance. This presentment for acceptance as incidental life of negotiable instrument is applicable only to a bill of exchange. Pero not all bills are required to be presented for acceptance. If you notice, tatlo lang yung mga cases kung saan yung bill of acceptance is required to be presented for acceptance to the drawee. First, if the bill is payable after sight or in any other cases where acceptance is necessary to fix the maturity date of the instrument. Take for example, yung example na 5 days after sight, pay to P, mga ganon. You need to present that for acceptance because it's necessary to fix the due date. Okay? O kaya 5 days after sight, 10 days after presentment, mga ganon. You have to present that for acceptance. Second, where the bill expressly stipulates that it shall be presented for acceptance. So, sinabi doon, pay to P or order 1 million and then sabi niya sa huli, presentment for acceptance, necessary. Then, kailangan mo siya talagang i-present for acceptance because it is been expressly stipulated or provided in the instrument that you have to present it for acceptance. And then letter C, where the bill is drawn payable elsewhere other than the place of business or residence of the drawee. So, for example, drawee is a resident of Baguio City, but then the instrument states that it shall be paid let us say in Manila, then in that case, you have to present it for acceptance even if it's not payable at a fixed period after sight, even if it was not expressly stipulated that it's to be presented for acceptance. Bakit? Kasi yung lugar kung saan nakatira si drawee ay ibang lugar doon sa sinasabi kung saan siya babayaran. Okay? Then it's required to be presented for acceptance. Going on further, What is now the effect of your failure to present an instrument when it's not required to be presented for acceptance? Well, there is only one effect of that. The drawer and the endorsers will now be discharged from their liabilities. Okay? And then, how is presentment for acceptance made? So dito, gusto ko lang i-consider nyo yung mga tanong na ito. Who can present the instrument for acceptance? To whom should it be presented? Where are you going to present it for acceptance? When are you going to present it for acceptance? What day and what time? Okay? So, who can present the instrument for payment? It shall be presented by the holder or by the duly authorized representative of the holder. So, the holder being referred to here refers to the person who is in actual physical possession of your instrument. Or, yung pinagsabihan ni holder na, oy, ikaw, punta ka doon kay DRAWEE to present it for acceptance, then that person now will fall under this phrase, authorized representative. To whom should you be presented for acceptance? Then you have to present it to the DRAWEE or to any person who has the authority to accept or to reject the instrument. Okay? And in connection with this, to whom are you going to present it for acceptance? If the bill is addressed to two or more DRAWEEs, okay? Dalawa ang DRAWEEs mo. Kanino? Well, it depends. Kung solidary sila, to any one of them. Kung joint sila, then both of them. Ganon. If the DRAWEE is already dead, kanino mo ipepresent? You have to present that to his personal representative. Okay? To his personal representative if the personal representative is known. And then another one would be when the DRAWEE has been adjudged as bankrupt, insolvent, or has made an assignment or transfer his rights or credit, then presentment for acceptance shall be made to, kanino? To the DRAWEE himself or to the transferee or assignee in interest. So take note, it does not mean that if you're already bankrupt as a DRAWEE or insolvent as a DRAWEE or you have already transferred your right to another, that you can no longer be made liable, okay, in the instrument. Pwede pa rin kasi sinasabi dito, presentment may be made to the DRAWEE himself or to the trustee or assignee. And then, when should you present the instrument for acceptance? You have to present it for acceptance before the instrument is overdue. So, before maturity of the instrument. And then, on what day? You have to present it on a business day. Business day that we are referring Mondays to Fridays. And then, at what time? Reasonable hour. Okay, so reasonable hour on a business day, sabi niya kasi doon. So what is reasonable hour? Reasonable hour refers to any time where the business is actually open. If you'll try to present it at the place of residence, then at any time before he goes to sleep or to rest, okay, on that particular day. When presentment for acceptance is excused, what are those instances where presentment for acceptance is not required to be made? Okay? Take note, what is excused here is only the presentment for acceptance. Okay? Presentment for acceptance is excused and a bill will now be treated as dishonored by non-acceptance in any of the following cases. First, where the DRAWEE is already dead. Okay? So, or has absconded, or is fictitious, or a person not having any capacity to contract. While ago, sabi natin, when the DRAWEE is dead, you have the option to present it to the personal representative, right? But then, the presentation to the personal representative when the DRAWEE is dead is simply optional. May or may not. Hindi importante, hindi necessary, okay? Hindi sa pilitan na you present it to the personal representative. So if the DRAWEE is dead, you may or may not present it to the personal representative. In which case, you have the option to consider presentment for acceptance as excused and you will now treat the instrument as dishonored by non-acceptance. Another situation whereby presentment for acceptance is excused is when the DRAWEE is already absconded. So DRAWEE has already escaped. It's now impossible for you to still locate the whereabouts or to know the whereabouts. Then logic follows that presentment for acceptance is also excused. If the DRAWEE is fictitious person, fictitious, di ba? Without real existence, kanino mo ipapakita? To whom are you going to present it if there is really no DRAWEE, di ba? Or when the DRAWEE is incapacitated. Okay? In which case, kahit pa i-present mo sa kanya, incapacitated nga eh. So, what will you expect from that incapacitated person? Next one, whereafter the exercise of reasonable diligence, presentment cannot be made. In other words, you exerted diligent efforts trying to locate the drawee, but the whereabouts of the drawee is no longer known. So siguro pinanawagan mo siya sa radyo, pinahanap sa NBI, CIDG, etc., but you failed to locate or to know the whereabouts, then you can now consider the instrument, you can now consider presentment for acceptance excused. And then the third one, where although presentment has been irregular, acceptance is refused on some other ground. Ano yung ibig sabihin na irregular? Presentment is regular if you have complied with ito. Who, to whom, when, day, and time. That's regular. But if you did not comply with all of these, then that's the time that presentment is said to be irregular. So if presentment is irregular, but the drawee refused to accept it, not because presentment was irregular, but for a different reason, you can also consider presentment for acceptance as excused and subsequently consider the instrument dishonored by non-acceptance. Okay? So, paano ang kwan mo doon? You complied with the, pumunta ka doon, halimbawa, sa lugar niya at an unholy hour, bahay niya yun, pumunta ka doon ng 2:00 ng madaling araw, natutulog pa siya. Ayaw niyang tanggapin. Bakit ayaw niyang tanggapin? It's not because natutulog siya. It's not because pumunta ka doon na unreasonable yung hour. Ang sabi niya, pumunta ka man lang dito, hindi ka man lang nagdala ng pandesal, ginising-gising mo pa ako para naman sana nakapagkape tayo. For that reason, I deny. Ayan. Kapag ganon, then you can now consider the instrument, presentment for acceptance, excused. Because although presentment was irregular, the acceptance was refused on a different reason. When is an instrument considered now dishonored by non-acceptance? If a bill is dishonored by non-acceptance when it was duly presented for acceptance and acceptance is refused or cannot be obtained. Ibig sabihin, acceptance is regular. You complied with the who, to whom, when, where, etc. And then the drawee did not accept it, or the acceptance that you were expecting from the drawee did not happen. And then another situation is when presentment for acceptance is excused and the bill is not accepted. Now, I do not know if you find this logical. When presentment for acceptance is excused and the bill is not accepted, how is that? Presentment for acceptance excused na nga, bakit bill is not yet accepted? Well, parang ganito lang yan. That is logical. Diba? One of the instances whereby presentment for acceptance is excused is when the drawee is dead. But even if the drawee is dead, you may or may not present it to the personal representative. Correct? So what did you do? You know for a fact that the drawee is dead. So instead of immediately considering the instrument, the presentment for acceptance is excused, you went to the personal representative of that deceased drawee and presented to the personal representative of the deceased drawee. Ano ang ginawa ni personal representative? Instead of accepting it, he dishonored. He refused to accept it. So, we have now a situation whereby presentment for acceptance is excused because the drawee is dead, but the bill was not accepted by the personal representative. In that case, you are also allowed to consider the instrument dishonored by non-acceptance. Okay? So for Unit 3, that will now be acceptance. What is acceptance? Okay, so we're now in acceptance. What is acceptance? Acceptance is the signification by the drawee of its assent to the order of the drawer. It's just like saying yes to the unconditional order of your drawer. Isn't it the fact that in a bill of exchange, the drawer is giving a command to the drawee for the drawee to pay the amount appearing on the face of that instrument? Okay? In which case, sabi natin, the acceptor is liable according to the tenor of his acceptance, not the tenor of the instrument. So, how will this acceptance be made? Acceptance, you have to take note that as much as possible, it shall be included in the instrument itself. It shall be made on the face of that instrument, okay? By writing the word accepted across the face of the instrument to be followed by your signature. And the promise to pay here, should be to pay only in the form of money and not in any other means. So take for example the following. I pay to Peter or order 1 million on March 1 of 2020, signed Mike to Alpha. So how will Alpha now, our DRAWEE, accept that instrument? Sabi natin, by writing the word accepted across the face of the instrument, and to be followed by signature, and as much as practicable, you have to include also the date of the acceptance. Okay, so accepted, signed Alpha March 1 of 2020. That's how to accept it, by writing the word accepted. And then there are ways by which you can accept that instrument. First is what we call as actual acceptance, and the other one is what we call now as constructive acceptance. And what is actual acceptance? Balikan lang natin to. Ito pala yung sinasabi ko kanina na accept na yung liability na acceptor is according to the tenor. So take for example, pay to Peter or order 1 million on March 1 of 2020. 1 million is the tenor of the instrument, correct? When a Alpha made the following acceptance, absolute acceptance ang tawag dyan. So he accepted it unqualifiedly. Ibig sabihin, the extent of the liability of Alpha would also be the amount of 1 million, and he has undertaken to pay it on March 1 of 2020. But if Alpha now, sinabi niya dito, accepted for 100,000, then 100,000 is what we call now as the tenor of his acceptance. That is the amount that Alpha wants to pay in the instrument. Ang tawag naman sa ganun na klase ng acceptance na ginawa ni Alpha is what we call as qualified acceptance, which we will discuss later. Qualified acceptance because he did not want to pay the entire amount but merely a partial or a portion of this 1 million pesos. Yung 100,000 lang ang willing siya na bayaran. And that's what we call now as the tenor of the acceptance. Okay? So, actual acceptance by writing the word accepted across the face of the instrument. And then, there is also what we call as constructive acceptance. Constructive acceptance, there is no actual acceptance here. But, for all intents and purposes, that is still considered as acceptance. Such as, if the DRAWEE will destroy the instrument after it has been presented to him for acceptance. So pagkatanggap niya, shredded niya, sinunog niya, pinunit niya, etc., then there is now what we call as constructive acceptance. Or in a situation whereby our DRAWEE likewise refused to return it within a period of 24 hours from the time it has been presented to him for acceptance. Why is that? Because as you all know, the DRAWEE has at least 24 hours within which to decide whether to accept or to reject it. So within the 24 hours, if he decides to reject it, then he has to return the same or to inform the holder of his decision not to reject the instrument. If he did not do that, the presumption is that there has been an implied acceptance. So failure to return the instrument within 24 hours connotes that there is now what we call as constructive acceptance. Okay? And then as much as possible, where will you place your acceptance? Acceptance shall be placed in the body of the instrument itself, on its face. But it is also possible that the acceptance will be placed on a separate piece of paper other than placing it or besides placing it on the face of your instrument. However, placing your acceptance in an allonge is a way on how to limit your liability if you are the acceptor. Why? Because if the acceptance has been placed in an allonge, the liability of the acceptor is limited only to those individuals who have seen that acceptance on that separate paper and who on the face thereof receive the same for value. Kung meron na yung acceptance na nakalagay sa allonge, kaya lang hindi niya nakita yung allonge na yon. Or nakita niya, kaya lang hindi siya nagtiwala na mababayaran yung instrument, then our acceptor in that case is not liable to that person. So he is not liable to the person who has not seen it. He is not liable to the person who has seen it but who did not believe that the instrument will be paid. Okay? So magandang gawin mo yan if you are the acceptor by placing your acceptance now on a separate paper because you can now limit the extent of your liability. But if you are the holder, meron ka bang right to demand that the acceptance will be placed not in an allowance but on a separate but on the instrument itself? The answer is yes. It is also the right of every holder to demand that the acceptance shall be placed in the instrument itself. That if you cannot obtain that acceptance on that separate you cannot obtain that acceptance to be indicated on the face of the instrument, you have the right to consider the instrument dishonored by non-acceptance. Okay? Ulitin natin. Yung drawee, he has the right to place the acceptance on the face of the instrument or on a separate paper known as an allonge. In which case, if he placed the acceptance in a separate paper, then the liability is limited only to those individuals who have seen it and who on the face thereof receive the same for value. But the holder of the instrument has also the corresponding right to demand that the acceptance will be placed on the face of the instrument itself. And if he cannot obtain that, then he can just consider the instrument dishonored by non-acceptance. Promise to accept when it is equivalent to an acceptance. Di ba sabi natin doon sa presentment for acceptance, presentment for acceptance shall be made before the due date of the instrument. Correct? Now, sinabi rin natin dito kanina that the drawee can accept the instrument within 24 hours. But that if he will fail to accept it within 24 hours, then the instrument is now considered to have been constructively accepted by him. However, if you will be asked the question, when can the drawee accept the instrument? The correct answer there should have been anytime. Why anytime? Because the drawee can actually accept the instrument before its actual existence. He can accept it before the due date, on the due date, after the due date, and even after the instrument has been dishonored by non-acceptance. That's why if you will be asked that question, when can the drawee accept the instrument? The correct answer there is anytime. So sabi ko kanina, acceptance can be made even before the actual acceptance of the instrument. The answer is yes. You can do that, but it should be made in writing. There must be a written promise to accept that bill of exchange. Hindi lang verbal yung promise na yon. That should have been a written promise to accept. And if you have placed your written promise to accept, to whom are you now liable? Again, just like in that situation whereby you have accepted the instrument in an allonge, you are liable also only to those individuals who have seen that promise to accept in writing and who on the face thereof receive the same for value. So, maganda na mag-accept before the actual existence of the instrument. Why? Because the liability of the drawee acceptor will be limited. Limited to whom? Limited lang sa mga nakakita at nagtiwala or naniwala na yung instrumento na iyon ay mababayaran. And then time allowed, yan, 24 hours. And if he did not communicate his intention to not to accept it within 24 hours, the presumption is that there has been constructive acceptance. What are the different kinds of acceptance? Well, ito, your general acceptance, acceptance to pay at a particular place, okay? And then qualified acceptance. Yung general acceptance, the acceptor here will bind himself in the instrument without any qualification. Kung ano yung nakasulat sa face ng bill of exchange, yun din yung extent ng kanyang liability. Kagaya nung illustration natin kanina na to, pay to Peter or order 1 million on March 1, 2020. Nung in-accept niya, accepted. Sign alpha March 1, 2020. This is what we call now as general acceptance. Okay? Pero halimbawa sinabi dito, pay to Peter or order 1 million on March 1 of 2020 in Baguio City. That is still considered general acceptance. If there is a specific place where you can place your acceptance, where you can make your acceptance, but that place is not limited only to that place, then that would still be considered general. Okay, balikan natin yung ito. General acceptance to a particular place is a general acceptance unless it is expressly stated that the bill is to be paid not there only and not elsewhere. Okay? So, ito naman yung mga examples ng qualified. If it is conditional, if it is partial, if it is local, qualified as to time, and then acceptance made by one, some or more of the drawees, but not all. Okay? So, gawa na lang tayo ng illustration dito kasi wala yata akong illustration na naigawa. Your bill of exchange, pay to P or order 1 million on November 1, 2020 in Makati City. Okay? And then to A, tapos signed D, the drawer. Okay, so yung acceptance ni A, ganito niya ginawa. Okay, so just imagine that the acceptance na isinulat ni A as follows. Accepted, signed A, and then the date, 10/20/2020. That is an example of what we call as a general acceptance. Or kaya, sinabi niya, accepted to be paid in Makati City. That's also general. Or sinabi niya, accepted to be paid in Baguio City. That's also considered general kasi hindi naman nilimit on that specified place. Pero kapag sinabi niya accepted to be paid in Baguio City only, yan, nagiging qualified na yan. Qualified as to local ang tawag dyan. Okay? Now, ano naman yung partial qualified acceptance? Partial qualified acceptance, you qualify the amount. So, accepted for 100,000. Then, that's partial qualified acceptance. And then, qualified as to local, yan. Accepted to be paid in, yung example natin kanina, Baguio City only, yan. Or, another situation is, as to time, accepted to be paid on November 1, 2020 at 1 p.m. only. Yan. Kapag ganyan, that's also qualified as time. Or, in a situation whereby, tatlo sila, B and C. Ayan. Pero sino lang ang nag-accept? Accepted, to be accepted. O, ganyan. Tapos, sino lang ang tumanggap? It was only A. Or it was only B. Kapag ganyan, there is still qualified acceptance. O kaya, B and C lang ang nag-accept. Then that would still be considered as qualified. Again, ang rule natin dito, it is the right of every holder to demand that the acceptance shall be made as general. If he cannot obtain general acceptance, or in a situation whereby the drawee is only willing to make a qualified acceptance, the holder of the instrument has the right to treat and consider the instrument dishonored by non-acceptance. So, to recap, ano yung mga karapatan ng holders insofar acceptance is concerned? It is the right of the holder to demand that the acceptance shall be placed on the face of the instrument. It is the right of every holder that the acceptance shall be made general. That if he cannot obtain such right, then it is his right to consider the instrument dishonored by non-acceptance. So even if the drawee is willing to make qualified acceptance, it is still the right of our holder to consider the instrument dishonored by non-acceptance. Okay? So that will be the discussion on that entire module 4. The next topic, hindi pa pala. Meron pa palang unit 4, presentment for payment. So tapusin natin to. Presentment for payment. What is presentment for payment? This stage in the life of your negotiable instrument is applicable to both bill of exchange and a promissory note. Not unlike in presentment for acceptance, which is applicable only to a bill of exchange. But when it comes to presentment for payment, it's applicable to both bill of exchange and the promissory note. So what constitutes sufficient presentment? Presentment for payment. Okay? So, consider nyo lang ulit yung who, to whom, when, where. Who has the right to present the instrument for payment? It shall be presented by the holder or any person authorized to receive payment. And then at what time? Reasonable hour. Okay? On a business day. You know the meaning of reasonable hour, which means that not a fixed period of time, but depending upon the nature of the business or on the place where you're trying to present it for payment. And then at the proper place. Where is this proper place? Proper place refers to the place is specified in the instrument, or if no place has been specified in the instrument, then at the address of the person, okay, who is required to pay it at the place of residence or his place of business. If no place of business or residence was indicated, then anywhere else you can find the person. So yun yung proper place na sinasabi dito. And then the person primarily liable on the instrument, okay, should be the one to pay that instrument. Okay? So when presentment for payment is excused, when? Where after the exercise of reasonable diligence, presentment required cannot be made. So it's impossible to comply with this proper place of presentment or reasonable hour on a business day. Then in that case, you can now consider the presentment for payments excused. Or in a situation whereby the drawee is fictitious person, because really there is no person to who will become the acceptor, and if there is no acceptor in that bill of exchange, there is no one who would actually pay the instrument. And then another one would be when there has been waiver of that presentment. Okay, it could be express waiver or an implied waiver. And then when will you consider the instrument dishonored by non-payment? The instrument is considered dishonored by non-payment when it was duly presented for payment and payments are refused or cannot be obtained. So in other words, you complied with the requirements, yung who, to whom, where, and when. But notwithstanding the same, the instrument has not yet been paid. And then the last one is presentment is excused and the instrument is now overdue and unpaid. Okay? So what constitutes presentment payment in due course? Payment in due course means payment made at or after maturity to the holder thereof and without notice that the title is defective. You take note of the meaning of payment in due course because it is only payment in due course which will now discharge the instrument. If there is any payment made not by the person primarily liable, and that payment has not been made on the due date or after the due date, that is not payment in due course. And if it is not payment in due course, it will not discharge the instrument. The instrument will still continue to be negotiable. It can still be transferred. It can still be negotiated. So that will be the last discussion on our Module 4. Next time, we will be discussing our Module 5. That will now be the notice of dishonor and then later on the discharge of your instrument. So that will be the last part of our negotiable instrument.